Hi guys, we're going to unravel another bar exam multiple choice question. This one will be a property question, specifically on mortgages. The first method we will go through will be looking at the call of the question, then the fact pattern, then the answer choices. The call of the question is, the bank is entitled to collect a deficiency judgment against. And with this, you should be able to confidently think that this is a property question. Because of the words the bank and deficiency judgment against. Seeing the question, you will want to identify who the parties are because you're wanting to find deficiency judgment against a specific person. So when you go through the fact pattern, it starts out, a woman owned Woodsage, a tract used for commercial purposes in fee simple and thereafter mortgaged it to a bank. So you've got the bank is the lender, the woman is the borrower, and Woodsage is the tract of land we're talking about. When you're looking at deficiency judgment here, you can identify right away. I would put the woman as one of the people that will likely be responsible for deficiency because she's the borrower. So you're always on the hook unless the lender lets you off the hook, and that would be what we would be looking for. She signed a promissory note secured by a duly executed and recorded mortgage. So she's got the mortgage and she's on the hook for that mortgage. There was no due on sale clause, that is no provision that upon sale the whole balance then owing would become due and owing. The woman conveyed Woodsage to a friend, so she's giving the property away to a friend subject to a mortgage to the bank, which the grantee assumes and agrees to pay. Now this gets a little bit tricky because we see that the fact pattern shows two terms that are very important in the mortgages questions, which is taking subject to and assuming the mortgage. They're putting it all in one sentence. Don't get confused by that. When you're taking subject to a mortgage, normally you wouldn't be responsible for the mortgage, but in this context here, it's saying it's the friend takes subject to the mortgage, which the grantee, meaning the friend, assumes and agrees to pay. So that's the more important aspect of it, is the friend, the grantee, assumes the mortgage, which means that the friend is also responsible for that mortgage and any deficiencies from that mortgage. Taking subject to here, don't let it trick you into thinking that the friend is not responsible because they take subject to. In this context, just think of it as she's taking this property and the property is tied to the mortgage. And in addition to that, she's agreeing to assume the mortgage, which means she's agreeing to take on responsibility of paying for that mortgage as well. Now, the friend conveyed Woodsage to his son. So I guess the friend, I was saying she, but here it's the male. So the friend conveyed Woodsage to his son. This conveyance to his son is, they say, subject to an existing mortgage, and there is no indication that the son is also assuming the mortgage. So here you can think that, well, not the son, because the son did not assume the mortgage. So make a note of that. The friend conveyed Woodsage to his son subject to an existing mortgage to the bank. A copy of the note and the mortgage that secured it have been exhibited to each grantee. So the grantees have seen the mortgage and the security, the interest and everything. So it doesn't matter whether or not they're responsible, whether or not they know that there is a mortgage. It's whether or not they take on the mortgage, whether or not they assume the mortgage. So that is really irrelevant to your analysis here. The fact pattern goes on to say, after the son made 3 timely payments, no further payments were made by any party. In fact, the real estate had depreciated to a point where it was worth less than the debt. There is no applicable statute or regulation. In an appropriate foreclosure action, the bank joined the woman, her friend, and the son as defendants, and the foreclosure sale, although the fair market value for Woodsage in its depreciated state was obtained, a deficiency resulted. So there's a deficiency, and the call of the question again is the bank is entitled to collect a deficiency judgment against, and the bank is going after the woman, her friend, and the son. These are all the people they're going after. If you had been going through and doing the application of the law with the terms, which the issues they were testing you on are assuming the mortgage and taking subject to, if you had gone through the analyses for those 2 subtopics, then you should have taken note that the woman and the friend are the responsible parties. The son is not. Here, the answer choice B matches up with that answer choice, the answer that you should have come up with. The answer choice B would be the best answer choice. In answer choice A, it says the woman only. The woman is on the hook because she did not receive a novation. That is, the bank did not let her off the hook by giving her a novation, meaning that the bank says, I will no longer hold you responsible for the loan. I will hold your friend responsible for the loan now. She did not receive a novation, so she's still on the hook. That is true. However, because her friend took the mortgage and assumed to pay for it when he took the property, then her friend is also responsible for the deficiency. Answer choice A excludes the friend. Answer choice C includes the friend, excludes the woman. You can cross out the answer choices that doesn't have the woman in there because the woman is always on the hook, so you don't even need to do the son's analysis for the son if you knew that. But you will have to for answer choice D, which has the woman, the friend. Now you have to decide whether or not the son is also responsible for the deficiency. And as we mentioned, since the son took subject to the existing mortgage, then the son should not be responsible for the deficiency. So the answer choice should be B. Now we will go through this MBE bar exam question from the top all the way down through the call of the question, then the answer choices. The fact pattern starts. A woman owned Woodsage. a tract used for commercial purposes, in fee simple, and thereafter mortgaged it to a bank. As I have mentioned, what you will want to do as you're going through the fact pattern, if that's the method that you go through, you'd like to use the most, you want to be identifying parties. And in this case, where it says woodsage, a tract of land, you should gather that this is a property question because of it naming a tract of land. Okay. So you will want to make a note of that, and if they switch it up, you can always change it, but at this point it looks pretty much like it's a property question. It could possibly be trespass, but they also use the term fee simple. It's a huge indication, and then mortgaged it in the bank. So this is likely, not only should you gather it's a property question, but it's a mortgage question. So get your thoughts into the frame mind of mortgage property question. She signed a promissory note secured by a duly executed and recorded mortgage. More confirmation that it's a mortgage question. There was no due on sale clause, so they're not likely testing you on the due on sale clause. That is, no provision that upon sale, the whole balance then owing would become due and owing. The woman convey woodsage to a friend. Now you've got the conveyance to a friend. At this point, maybe if you want to keep track, you can start doing something like this. Woman, okay, and then to friend, subject to a mortgage to the bank, which the grantee assumes and agrees to pay. You've got two terms that are associated with mortgages: subject to a mortgage and assume. Usually, you may be thinking that these are opposite terms. When you take something subject to the mortgage, when you take the land subject to the mortgage, that means you are not responsible for paying the mortgage. When you take it and you assume the mortgage, it means that you are taking on the responsibility of paying for the mortgage. In this context, when they're putting it in one sentence, don't get confused by that. Instead of thinking of the subject to the mortgage as not being responsible for the mortgage, what it really means, and you can be thinking of this in general, when you take subject to the mortgage, you can think of it as you're taking the land that is also tied to the mortgage. Whether or not you will be responsible for it will be whether or not you will assume the mortgage. So at this point, the friend assumes the mortgage and agrees to pay for it. The friend then conveys woodsage to his son, subject to an existing mortgage to the bank. In this case, the son takes subject to the mortgage, which means that the son is not responsible for the mortgage, unlike the father. A copy of the note and the mortgage that secured it had been exhibited to each grantee. After the son made 3 timely payments, no payments were made by any party. So now there's a default, likely. In fact, the real estate had depreciated to a point where it was worth less than the debt. And so there may be some deficiency, is what they're hinting at. There is no applicable statute or regulation. In an appropriate foreclosure action, the bank joined the woman, her friend, and the son as defendants. So the bank is bringing in the woman, the friend, and his son as defendants for having to pay for the mortgage that has now gone in default. at the foreclosure sale, although the fair market value for Woodsich in its depreciated state was obtained, a deficiency resulted. So another mortgage term, deficiency. And the call of the question is the bank is entitled to collect a deficiency judgment against, and it's the parties that they want to collect against are the woman, the friend, and the son. We had said the friend assumed the mortgage. The son did not assume. So the woman, as the borrower, will always be on the hook. The friend, since he assumed, he will be on the hook. The son did not assume, so the son is not on the hook. So you would be wanting to look for an answer choice that includes the woman and the friend, not the son. And that looks like answer choice B is the answer choice that includes both the woman and the son. The answer choice in A only includes the woman. It excludes the friend, so that's not a good answer choice. Answer choice C includes the friend and the son. Well, answer choice C you can cross out because it doesn't include the woman, and you should, even if you were unsure of the friend and the son, you should know that the woman will be on the hook because she's the original borrower. And unless the bank has given her a novation, that is a novation where the bank says that they will let her off the hook and go after the friend for responsibility on that mortgage. She is not off the hook, so she's always going to be liable for the mortgage as well as any deficiencies. Now you are between B and D. The son, whether or not the son is liable, that's the difference between B and D. So go back to check the fact pattern where it says the son takes subject to. And again, this is where learning your substantive law is very important. When you take subject to a mortgage, you are not taking on responsibility for paying the mortgage. Therefore, you are not responsible for any deficiencies that come out of that mortgage. So the best answer choice and the only answer choice is B. Now we will go through this question. First, reading the call of the question, then going through the answer choices, then going back up to the top to read the fact pattern, then answer choices, or then the call of the question, then the answer choices. The call of the question is, the bank is entitled to collect a deficiency judgment against. So now, when you look at this, the bank deficiency judgment, this is a hint that it's a property question. Answer choice A, the woman only. Answer choice B, the woman and the friend only. Answer choice C, the friend and his son only. Answer choice D, the woman, the friend, and the son. I think this is one of those types of questions that you really cannot answer or eliminate any answer choices without looking at the fact pattern. But you should gather that they're testing you on deficiency judgment and the bank likely lending money to the person. So going through the fact pattern, you will be looking at the woman, the friend, and the son. So whenever the names come up, you would want to highlight and see whether or not they would be responsible for any deficiency. At this point, though, you should gather that this is likely a mortgage question because they're talking about deficiencies. So the idea is borrowers are liable for deficiency. So if someone is a borrower, they are liable unless they get a novation. A novation in the context of mortgages is where the lender agrees to let the borrower off the hook and replace the borrower with a different party who will be responsible for that mortgage. That would be what you would be looking for. If someone assumes the mortgage, then they also take on the responsibility of paying off the loan and any deficiencies that come with that loan if there is a default. So those things are what you will be looking for with respect to the woman, the friend, and the son. The fact pattern starts out: a woman-owned woodsage, a tract used for commercial purposes in fee simple and thereafter mortgaged it to a bank. So here you've got the woman, she's getting a mortgage for this property. That means that at this point, unless we see novation later on, she is on the mortgage. She's the borrower, so she would be liable for deficiency. She signed a promissory note secured by a duly executed and recorded mortgage. There was no due on sale clause, that is, no provision that upon sale the whole balance then owing would become due and owing. The woman conveyed woodsage to a friend. Now we've got a friend that subject to a mortgage to the bank, which the grantee assumes and agrees to pay. Here we've got two mortgages, legal terms of art, subject to and assumes. And as I mentioned, if you take subject to the mortgage, generally you would not be responsible for the mortgage or its deficiencies. However, if you assume the mortgage, that means, as it says here, he agrees to pay that mortgage on behalf of the woman. Right? The tricky part right here is that throwing these two terms in the same sentence, the two terms seem to be the opposite of each other. Don't get confused by that. You should be thinking of the term taking subject to a mortgage in this context, not so much that they are not responsible for the mortgage, but when you take subject to a mortgage, think of it as you're taking the land that is also tied to the mortgage. They're qualifying this by saying that which the grantee assumes and agrees to pay. That means that the friend agrees to pay on behalf of the woman for the mortgage. Therefore, now you can see that the friend, because it says the friend assumes the mortgage, agrees to pay the mortgage, the friend is liable for the deficiency, if there are any. Okay. The fact pattern goes on to say the friend conveyed woodsage to his son. We've got the third party that we're looking for. His son, subject to an existing mortgage. Now the son is taking subject to the existing mortgage. He's also taking the land that's tied to the mortgage, but it doesn't qualify it by saying that he's assuming that. That means he is not liable for the deficiency. A copy of the note and the mortgage that secured it had been exhibited to each grantee. Irrelevant fact, essentially. After the son made 3 timely payments, no further payments were made by any party. In fact, the real estate had depreciated to a point where it was worth less than the debt. There is no applicable statute or regulation. in an appropriate foreclosure action, the bank joined the woman, her friend, and the son. We know that going after these three parties at the foreclosure sale, although the fair market value for Woodsage in its depreciated state was obtained, a deficiency resulted. So now the bank is going after these three parties, and the call of the question asks, the bank is entitled to collect a deficiency judgment against. Answer choice A, the woman only. If you had in the back of your mind, or if you had taken notes here, you would be thinking the woman and the friend are responsible and not the son. That answer choice is in B. So that should stand out to you at the moment. You should clearly, even if you were not sure because of the language in the quotation marks for how the friend and the son takes it, you should know that the woman is responsible because there are no facts in the fact pattern that discusses novation or the bank letting the woman off the hook. So you can cross out C because you know it has to include the woman. The friend then, if you can eliminate the friend, you can eliminate B and D. So maybe that's where you can go next. The friend, again, assuming the mortgage, if you had studied your substantive law well, you would know that this friend saying that he agrees to pay for the mortgage should also be responsible for the deficiency. So you cannot eliminate B and D, unfortunately. Now you're forced to, and so if you are able to see that the friend is also responsible, you can eliminate A. So you at least go down to B and D and have to decide whether or not the son is also responsible. And again, unfortunately, this has to do with you learning the substantive law and associating the term taking subject to without assuming the mortgage means that you're not responsible for the mortgage or any deficiencies. And that is why the correct answer should be B.